Hi everybody, Jack Meligan here with you again from the Plaintiff's MSA and Lien Solution. Hey, does the idea of a $250,000 fine keep you up at night? Well, that's what's happened to the plaintiff's trial firm of Myers, Rodbell, and Rosenbaum out in Maryland, who just signed a settlement agreement with the United States government to pay $250,000 restitution because of not paying and not dealing with a client's Medicare conditional payment. Now, in looking at the initial publication and announcement of this, it appears the underlying settlement was for $1,150,000. Now, based on a 1/3 contingency up to a 40% contingency, which are pretty typical, then I would estimate that this client was probably looking at a net before a reduction for any costs and any other liens that might have existed in the case that we don't know about yet, but probably looking at a net of $690,000 to around $750,000. And I'm not sure if the $250,000 that the law firm is paying to Medicare represents the full amount of her conditional payment, or maybe the full amount of the conditional payment was $125,000, and the $250,000 that the law firm is paying to Medicare or to the United States government represents the double damage issue that you're all aware of. But either way, I think what may have happened here is that it's possible that the law firm settled the case and then obtained the Medicare conditional payment report and realized it was way too much. Maybe the client complained and said, like I've heard many times in a conference room, I'd have never settled this case if I'd have known this was all I was going to get. There is a very easy solution to this. And that is, you've got to know, you've got to have a really good grasp in today's settlement climate. You've got to have a really good grasp on what the amount of the potential Medicare conditional payment obligation is going to be. And you should have already obtained that information and have challenged any medical expenses or costs that are in that conditional payment report that are unrelated to the injuries or conditions that are going to be the subject of your client's settlement. Now, you can continue to have your staff handle these things, and of course they're going to live in mortal fear that they'll get sued, or they'll get the firm sued, and the staff will get fired if they have an issue like this. Or you can outsource it to the people who every day deal with these issues and can help you bring your cases to closure at the same time that you have near finality on the amount of the Medicare conditional payments. How do we do that? Call us and we'll tell you. We're here to help you avoid these types of results. This is the biggest one I've seen yet, and $250,000 probably keeps anybody up at night. If you want to know how to fix this and how to prevent it from happening in your firm and how you can get to the time of settlement and know almost to the penny what the conditional payment obligation is going to be, call us. This has been Jack Meligan for the Plaintiff's MSA and Lien Solution. Be back again to you soon.